The time is 12:00 p.m.
Hi, everyone. Thank you for joining us today. I'm Sarah Brand.
Well, that's okay. We're gonna let Liz make sure that that's okay, Dan, because her medical expenses at her assisted living are going to offset all that.
Everyone, please be sure to mute yourselves. This is a meeting, so we can hear everything. I'm Sarah Moran, Development and Program Manager with the Bar Association. Thank you so much for joining us today. We have a great crowd, great presentation that we do annually. I do want to mention an upcoming program we're putting on with the bar. It's our 3-day trial practicum series, where we have experienced trial lawyers give hands-on practical training to new trial lawyers or anyone who just wants extra trial experience. So that's April 17th, 18th, and 19th, being hosted at the bar's conference room. So I'd love to have some of you there, or if you have new associates at your firms, if you want to spread the word, that'd be great. As far as today's program, you'll receive your attendance certificate, evaluation form, and materials via email from me in the next couple days, so keep an eye out from that. Again, keep yourself muted. We'll have put your questions in the chat for at the very end. There is a lot to get through today. I think that's it on my end, and I will turn it over to Tracy Riley, who is one of your co-section presidents.
Hello, everyone, and welcome. Thank you so much for joining us today. We are very pleased to have Julie Woods giving her fantastic updates. Julie, as you all know, worked for the Contra Costa County Court System, Judge Sugiyama, who joined us today too. So welcome, Judge Sugiyama. It's so good to see you. Julie is now physically here in Northern California, where her heart remains, but she is working for the LA County Court System. So welcome, Julie, and thank you so much. I don't want to take time away from you because I know you have a packed program for us, so please take it away.
Thank you so much, Tracy, for that lovely introduction, and hello to all my friends and neighbors. Happy to be here. All right, let's get this rolling. Happy New Year. As you know, this is one of the hardest presentations to give and also one of the hardest presentations to listen to. So I'm going to try and make it fun and memorable so these cases stick with us. And let's get to it and review the appellate decisions from last year that may affect our practice in probate. First case, Young versus Hartford. It's the final judgment. Do, 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 do. I had music, it didn't work. Okay, so this is suspension is not final under Probate Code 15642. So I love some of the language of this case, and I've quoted cases heavily throughout this presentation because no one says it better than the Court of Appeals, and I really like what I call their nuggets. So here are some quotes. Finality is a powerful theme in appealability jurisprudence. There's a final judgment rule, which means that you can't do piecemeal appeals with multiple appeals, usually because it's oppressive and costly. So typically in a civil case, you wait for, the final judgment from which you can appeal. Probate's a different animal. The concept of finality is handled differently. It's structured around a fiduciary relationship in probate, and cases may encompass many separate disputes. So we all know probate is kind of like complex civil litigation, and people don't give it enough credit because you'll have one case with several different proceedings, several different matters, all interrelated, all of which have their own calendar numbers, et cetera, et cetera, et cetera. Well, under Probate Code Section 1300, you can appeal certain types of orders. There it is, 1300. So the court says, we emphasize that despite these procedural distinctions, the probate courtability structure also embraces finality as the concept. So just because there are many different moving parts in probate doesn't mean that the final judgment rule doesn't apply. It just applies in a way that fits for probate versus regular civil matters. So here is the scenario in this case. The court suspended the powers of the trustee and the trust protector under Probate Code Section 15642. As we all know, that's a removal statute, but has a carve out in a subdivision, I think it's E, about suspension. So there was an appeal in this matter of the suspension order, and the trial court was affirmed. what happened was the Court of Appeal said, suspension is not the same as removal. It's a provisional remedy. It's something you do in the interim of removal. So it's really not the final judgment in a matter. So you shouldn't be able to appeal from a suspension. So under Probate Code Section 1300B, removal orders are appealable, but the suspension orders are not, as concluded by the Court of Appeals. Furthermore, there's a footnote in Schwartz versus LeBeau, which is the landmark case about suspension of trustees, and it says that in that footnote of that case, that suspension is not of itself an appealable order. So here in this instance, the Court of Appeal held that suspension of a trustee's powers is a provisional remedy, not a final one. Final judgment rule doesn't apply. Wait until you remove the trustee. Next, this is actually pronounced Rich versus Rich. So you shall not pass a non-probate IRA to an omitted spouse. So as we know, I don't know if you can still see me on the screen besides this lovely GIF, but as most of you know, in general, an IRA account is a non-probate asset as long as there's a beneficiary designation. So in this instance, we're talking about a non-probate asset IRA that an omitted spouse is claiming. And the gist of this case is an omitted spouse's share does not include proceeds of an IRA when the beneficiaries are trusts. Let's take a look. Basic principles, omitted spouse. When a spouse dies and doesn't provide for the other spouse in their testamentary instruments, their wills, their trusts, etc., because they were created before marriage. So I jotted down a holographic will on a piece of paper before I ever met my husband saying, leave my 3 cents, because I'm a public servant, to my mom and my dad, okay? And then I marry my husband, and he's not provided for in that will because I hadn't met him, hadn't married him yet. He now has a claim for my 4.5 cents that I now own because he, under the omitted spouse statutes, I gotta minimize Judge Sugiyama, you're making me nervous. So under the omitted spouse statutes, he now has a claim to part of my estate because he was omitted from the estate plan, not intentionally, but because of the fact that we were not yet married. So another basic principle that you need to be aware of for this case is that an IRA is a non-probate asset, as I had just mentioned. So you go to the beneficiary designation. Ms. Lauer, please mute yourself so we don't hear attorney-client privileged information. Thank you. So you look to the beneficiary designations, you go to the mattresses. Scenario, testamentary trust, as we all know, that's when a trust and a will have a baby together. Within the provisions of the will, trust language comes in. So first you administer the decedent's estate, then you distribute that property to the trust, and you move forward with trust administration. In a nutshell, that's testamentary trust. So in this instance, a testamentary trust created 2 subtrusts. Remember, subtrusts are separate trusts once they're funded and created. So anyway, it created 2 separate trusts for 2 daughters. The IRA beneficiary designations that the decedent had named the 2 subtrusts, one for each daughter, as the beneficiaries. So the trial court denied the surviving spouse's petitions to include the IRA proceeds in calculating her omitted spouse's share. The Court of Appeal affirmed IRA proceeds never pass through the decedent's testamentary trusts to the beneficiary's separate trusts. So procedural history. Surviving spouse filed a petition that sought an omitted spouse's share of the decedent's estate. She argued the proceeds of the IRA were part of the estate, and she should receive a share because those proceeds had to be marshaled through the testamentary trust before they could get distributed to the subtrusts. So she claimed, I've got a share of those. And one of the daughters demurred. Her grounds for the demur were that the IRA proceeds would pass directly to the separate trusts, not through the testamentary trusts, and that they fell outside of the decedent's estate for the purpose of calculating the omitted spouse's share. So Judge Rosenblum in LA, the trial court, overruled the demur, ruling that an IRA's proceeds can sometimes be included in a estate. Actually, it was a different judge. I'm sorry. Two judges come into play here. Trial court overruled the demur, saying that IRA's proceeds can sometimes be included in a decedent's estate, and that the IRA proceeds in this case would pass to the subtrust and thus essentially be paid into the actual trust. So then the spouse and the daughter reached a settlement, but they had a carve out saying, we're not going to include the IRA proceeds in that. Let's get to that later. Spouse turns around and files two petitions, one regarding each separate trust, which was a subtrust, because remember, they're their own trusts now, common basic error, regarding her entitlement to a share of the IRA proceeds as part of her omitted spouse's share. A different judge, this is where Judge Rosenblum, brilliant, came in, and he dismissed with prejudice the spouse's petitions. His reasoning was IRA proceeds were not part of the decedent's estate, and hence were not subject to the omitted spouse's share. Take a look at Probate Code Section 5000 if you haven't. The proceeds constitute a non-probate asset. The IRA beneficiary designation form specifies the proceeds would flow directly to the daughter's separate trusts. And the court ruled that the prior demur ruling in the spouse's favor was not controlling. Like another judge may have ruled on that demur, but here's my ruling now. Court of Appeals said, although IRA proceeds can sometimes pass through a trust, such as when a beneficiary designation lists on the IRA, the decedent's trust. Here, in this case, it never became a part of the trust for the purposes of calculating the omitted spouse's share. It's undisputed the decedent held the IRA in his individual capacity and not by the trust. And it's undisputed that the decedent designated the separate trusts for the daughters as the beneficiaries of the IRA proceeds. Thus, they never passed through the trust. P.S. Demur rulings aren't binding on a different judge making later rulings on the merits. Score. All right, next. Who dat? Estate of Williams, only because I didn't know you existed. The burden of proof is on the omitted child to show the sole reason for the omission is because the parent was unaware of their birth. Okay, basic principle. Pretermitted child. It's kind of the same thing as an omitted spouse. That's why I have these cases together. People refer to it as omitted child. Technically, it's pretermitted child, but this is fine. Afterborn child omitted from a testamentary instrument is presumed to have been omitted inadvertently and be entitled to a share of the estate. Okay, let's go back to my one-page holographic will leaving 3 cents to my parents 10 years ago. I have since gotten married and had a baby. That baby is not a part of the holographic will that I made. Because she was born after I made the will, if I die tomorrow and the only will that's found is that will, then she is entitled to a statutory share of my estate. That's what omitted or pretermitted child means in a nutshell. Probate Code Section 21622 is where you can find the specifics on that. Current law presumes a child born before the execution of the relevant testamentary instrument was intentionally omitted. Keyword, presumes. Why do we like presumptions? Because they are rebuttable, and as attorneys, that's how you can get paid, for doing work to rebut the presumption. Okay, or to prove the presumption. So a presumption of the pretermitted child is only overcome if there's an intent to omit the child that's apparent in the testamentary instrument. So I say, and if I have any kids, I don't want them to get bupkis, or I want them to get bupkis, that's an intent to omit any further children. The testator devised substantially all the estate to the omitted child's other parent. So I give everything to my husband, regardless of whether we have kids. Or evidence establishes that the testator made a gift to the child outside of the estate in lieu of a testamentary devise. So I've got 4.5 cents in a car, and I left the car to my daughter, so she's been provided for. Pretermitted child continued. It's interpreted by this case, Rallo versus O'Brien, where they unambiguously carved out a distribution right for unknown children only if they can prove the only reason the decedent did not provide for them was because the decedent didn't know they existed. So I didn't know this kid existed. That's the only reason I didn't provide for them. Maury Povich stuff. A general disinheritance clause proves a testator's intent to exclude potential children, even those whose identities are unknown, such that the decedent, the testator, did not fail to provide for an unknown child solely because the testator was unaware of the child's birth. How do we apply that in this case? Here's what happened. Setting the scene. The petition to receive a share of her father's trust as an omitted child alive at the time he executed his trust documents. So a daughter comes in and petitions to receive a share of her dad's trust, saying, I'm an omitted child. I was alive when he executed the trust documents. I should have been provided for. So the trial court found credible the other child's testimony that the father was aware of, but didn't provide for his other 4 known children. So he may not have known that she existed. But out of all his kids, he only provided for these 2. Okay? He had lots of kids, only provided for 2 of them. Unknown kid comes in and says, I'm an omitted child. And the trial court says, no, he didn't just disinherit you because he didn't know about you. He only wanted to provide for these 2 children. So the daughter comes back and appeals, arguing the trial court misapplies the pre-termitted child statute. And the Court of Appeal affirmed because she failed to carry her burden of showing the only reason, the sole reason that she was omitted was because her father was unaware of her birth. So the father's omission of 4 known pretermitted children and his naming as beneficiaries only the 2 other children resulting from his marriage shows his intent that only those 2 children should receive a share of the estate. So the other 4 and this petitioner were out of luck. Next case, Estate of Flores. Donnie, you're assigned out of your element. An 11-700 heirship proceeding does not determine assignment rights. So this was a Judge Luna case out of LA. This is a fun one. An heir hunter firm informed Donald that he was the heir of a nephew he never knew existed. Donald said, this is a scam, and assigned his interest in the estate to John. Guess what happens? Turns out there was money in the banana stand, and it was not a scam, and this case was worth a decent amount of money. So Donald assigned his interest to John. John filed an heirship petition. There was a determination that Donald and John were the nephew's heirs, each entitled to 50% of the estate, which was good money. So John, who received the assignment, died before final distribution, and Donald goes, oh, I want that money after all. Sit down, Donnie. In a petition for final distribution, the nephew's personal representative took into account Donald's assignment. Donald objected. He claimed the 11-700 order was conclusive as to persons entitled to distribution of the estate. In other words, that it overrode the assignment. So he said, hey, court, you determined who the heirs of this estate were under an heirship petition, 11-700. And so that really vitiates my previous assignment, gimme. And the trial court said, no, tut. Donald, you assigned your interest to John. It's unaffected by the heirship petition. And the Court of Appeal agreed. Heir rights are not the same as contractual assignee rights. The trial court concluded that the issues in the heirship petition were to determine who the heirs of the estate were and their respective percentage of interest in the estate, and the order decided which individuals statutorily entitled to inherit from the decedent, but did not decide the distribution of those interests. On appeal, Donnie, please, argued the 11-700 heirship order was binding and conclusive as to the distribution of decedent's estate, and argued the trial court erred in issuing an order that gave effect to the assignment of his share in the estate to John. And here's a nugget. The court said Donald's arguments are so inconsistent with case law, which has long drawn, you never want that to be said of your case, which has long drawn a distinction between heirs, devisees, etc., and persons whose only interest in the estate is derivative of the rights of them. A distribution order, so petition for final distribution, could not be deemed to have determined an assignee's or grantee's rights under an assignment or other instrument. There you have it. So remember that under Probate Code Section 11-700 proceedings, they're permissive. You don't have to file an heirship petition. And once you do, heirs don't have to respond. They can file a statement of interest, but if they don't, they can't come back later and say, I'm an heir, because they didn't do it within the statutory time limit and in the manner prescribed by the statute. So an 11-700 order determines persons entitled to distribution and specifies shares No carve out in there for the assignments. And remember, probate is in rem, and these petitions are in rem. And what that means is it's deciding the disposition of the thing against the whole world. It's not this guy versus this guy. It's deciding the thing in rem jurisdiction. Back to 1L year. Ooh. Okay, settles the rights of all persons claiming as heirs the decedent, whether or not they are named in the petition. Underlying rights of an heir advisee or legatee to a share of the estate are conclusively determined, but the rights of the assignee against anyone else arise by contract. So look, if it's not raised in the 11-700 proceeding, the assignee's rights against the heir, advisee, or legatee are not barred by the court's order determining the person's entitled to a direct distribution of the estate. Next, the court will find the kid is mine, so let me visit him now, if that's okay. So this is visitation is okay to a presumed parent during a pending Uniform Parentage Act proceeding if it's in the best interests of the child. So this harkens to portions of family law, which we will see again later in the presentation. Uniform Parentage Act, look it up, Family Code Section 7600 at SEC. Fee hand versus Superior Court. So the court's statutory scheme, the legislature, the public policy, basically everybody agrees to put forth the policy that child custody and visitation, whether it be physical or legal custody and visitation, those determinations, the overarching concern is what is in the best interests of the child. In a guardianship, the number one thing you look at is what's in the best interests of the child. In a conservatorship, you look at what's in the best interests of the conservatee or proposed conservatee. So here, best interests of the child is the overarching concerns because it's in the interests of society to ensure the health, safety, and welfare of children, going back to Aristotle. Even worse than 1L. Okay, broad authority of courts to enter such orders during the pendency of a proceeding. So courts don't have to wait and say go to determine what's in the best interests of a child. The aim is to preserve the parent-child relationship and ensure children have frequent and continuing contact with both parents after, the parents have ended their relationship together. And you want to encourage parents to share the rights and responsibilities of child rearing, except when that's not in the best interests of the child. So let's take a look at what happened here. Family Code Section 7604 says a court may order pendite lite, I don't speak Latin, relief consisting of a custody or visitation order if the court finds both of the following. A parent and child relationship exists. B, the custody or visitation order would be in the best interests of the child. But the statute does not require such relief, and it doesn't prohibit the court from ordering such relief in other situations. And the framework doesn't suggest that it's the exclusive authority to be relied on either. Remember, best interests of the child. So what happened in this case was the court held that Family Code Section 7604 does not preclude courts from awarding temporary visitation in Uniform Parentage Act actions. So while the UPA action is pending, the court, if it's in the best interest of the child, can order temporary custody and visitation.
No.
Okay, next case is Trotter versus Trotter Van Dyke. You've got mail, not a trust amendment. I think we're all old enough to remember this. Okay, you've got mail, not a trust amendment. An unsigned email does not a trust amendment make. So for estate planners, a questionnaire that you send out in anticipation of an estate plan attached to an email, as much as you think that's great evidence of what an estate plan should be, it's not. It's not the actual estate plan. It's an email sent in anticipation of the estate plan. So let's guess what happened in this case. Get the estate plan signed before the guy dies. Okay, scenario, petition for instructions. Someone comes to the court and says, Your Honor, what do we do? But they have to frame their relief. Common mistake that I see attorneys make in court. Frame your relief that you're requesting in the petition for instructions. So they came and they said, do certain emails from the settlor constitute a valid amendment to the trust? Like, it's changing the trust beneficiaries. Is this a valid amendment? And the trustee in neutral, with all these duties of loyalty, impartiality, etc., said, hey, court, we don't know how to treat this email. Trial court found the settlor's writings were insufficient to constitute an amendment to the trust. No dice. Ordered the trust to be distributed to the original beneficiaries. Oh, this was a judge, now Justice Kennedy case out of San Diego. Brilliant. This matter was affirmed. There were some interesting issues on appeal. This was a fun one. Okay, first, there was no signed document amending the trust. There was just this email with this questionnaire. Even though there was handwriting of the settlor on it, still didn't count. But also the electronic signature provision. So this attorney comes forward and goes, well, what about the electronic signatures provisions under the civil code? And tried to argue that way. And the Court of Appeals said, no dice, nice try. And but then Judge Kennedy also said, it doesn't count under the Uniform Electronic Transactions Act. But that's nice to know it exists and have that in your pocket. The other issue on appeal was the settlor's writings did not adequately express an intent to amend the trust by the writings themselves. So as much as they thought there was enough there, there really wasn't. Let's take a deeper look. So there were emails between the settlor, the estate planning attorney, and the trustee saying, my mind is clear. I know how to move forward. I want to remove a beneficiary and change distributions. I'll be available to discuss it. Give me the questionnaire. Here's the questionnaire signed and sealed and delivered back to you with my handwriting on it. And then settlor has a surgery and dies. Welcome to probate. Trustee turns around and petitions for instructions and says, do the writings remove the beneficiary? And the trial court said no, because the emails and the questionnaire were instruments in writing delivered in accordance with the provision of the trust, but they were not signed. And no, it's not an electronic signature, because under that UETA, there's actually carve out saying that wills and trusts and stuff, or wills and testamentary trusts and stuff don't count. So in this instance, it was held that it was mere correspondence. Writings did not show the settlor intended the emails and questionnaire themselves to make the disposition of property. The language and context all shows that it was in anticipation of an amendment. Lucky beneficiaries. Newell versus Superior Court. All estate. Are you in good hands? So here, when a trust contestant discovered the trust real property was sold and the real property was purchased, they filed an amended petition to add a claim for constructive trust and filed a lease pendant saying, hey, that new real property, that was actually a purchase with trust funds. We should get that. The trial court said no and expunged the lease pendants, and the Court of Appeals said, ooh, you're wrong, and found that there actually was a real property claim in the amended 17-200 petition. That's my spoiler alert, but let's do a deep dive. Okay. Here are the facts. Daughter was supposed to be the trustee and the only beneficiary of her parents' trust, but after her father died, she learned he amended the trust to name his caregiver instead of her. Ooh. She filed a petition to challenge the validity of the trust amendments, discovered that the caregiver used trust assets to purchase a house. Daughter recorded lease pendants and amended her petition to include a request for constructive trust on that new house, and the caregiver moved to expunge lease pendants. The trial court granted the motion to expunge and found the daughter's petition did not contain a real property claim. Now, this case, as easy as it sounds, when you take a look at the actual maneuvers and language that the court and the petitioner, etc., used, it was actually an intriguing argument. So it's not as simple as it seems on this slide, just like footnote if you ever read this case. So the daughter filed a petition for a writ of mandate, arguing if she won, the 17-200 petition would affect title to the property. And the Court of Appeal agreed, and they granted the petition for writ of mandate and directed the probate court to vacate its order and enter a new order denying the motion. And there is a little picture from the most important World War II movie of our time. So at the end of the day, if you're purchasing a real property with trust funds and you allege a constructive trust over that by the amended petition thereafter the discovery, that's a trust asset and you stand to get it. So that's why the writ of mandate was issued. So the parties' arguments were the caregiver moved to expunge, arguing the daughter's petition did not contain a real property claim, and daughter opposed, arguing, yes, supplemented, it really did, because the result will affect title and possession of the real property. Trial court found because the caregiver purchased it after the daughter filed her petition, none of the claims implicated the property, but remember, she amended it later. And daughter's request for a constructive trust was not the trial court reasoned that the request for a constructive trust on the real property was not a real property claim, but was merely an effort to preserve trust assets during the pendency of the litigation. Back to some basic principles, lease pendens. It's a document, if you're not aware, which you should be, it's a recorded document that gives constructive notice to all the world. You record it on title that an action has been filed that affects title to or right to possession of a real property. So, hey world, we filed a lawsuit. So if you buy this house, you're subject to the outcome of the lawsuit and you're on notice. So what motion to expunge does is it says, hey, that lease pendant should have never been recorded to cloud title. Please take it off because the pleading, for various reasons, one of which is the pleading doesn't contain a real property claim. And so what's a real property claim? If you take a look at the Code of Civil Procedure, it says that it's a cause of action that would, if meritorious, affect title to or right to possession of a specific real property. And in this instance, remember, the court had said, well, there's no specific real property claim implicated in the first petition, and the second petition only talks about constructive trust, so it's not directly against the real property, but practically speaking, and as a matter of policy, as the courts of appeal decide, they said, no, the constructive trust would be over this real property. And furthermore, it's a real property claim because when you record deeds on title for trust property, it says, grant deed to trustee on behalf, so-and-so on behalf of the trust, leaving in trust. So because trustee ownership is on the deed, that's a pretty big indicator that it's a real property claim. So if the trustee is removed and a new trustee is appointed, there's a deed and title change, and that's a real property claim. So this was sent back to the trial court. Godoy versus Linzer. Godoy, mate. You can't keep it in the family. And to do so is an unreasonable restraint on alienation. Here are the facts. Mama named her 3 kids as beneficiaries of her living trust. Her trust asset was her house. And but she really worked her whole life for this house. And she made it clear to her kids, like, you're each going to get an equal interest in the home. And when I die, and you can only sell your respective shares for an amount to each other, and here's the amount, it was well below fair market value, and only to each other, to keep the home in the family. Mama died, and 2 kids said, I don't want this kept in the family. Please, cash me out. It's like a partition action. There's a policy in the state of California that no one can be forced to hold real property title with someone else. You can get out of it. Follows the same principles here. So 2 kids petitioned the probate court for an order determining the trust instrument unreasonably restrained their ability to alienate their interests in the real property. And the one kid who wanted to keep the property in the family with the other 2 wanting out said, ooh, I could get this on the cheap. So of course they objected. And the probate court granted the petition and declared the amendment void. This is Judge Small out of LA. The amendment imposed unreasonable restraint on alienation, violating Civil Code Section 711, and the Court of Appeal affirmed. Let's do a deep dive. So the trust terms said each kid gets 1/3 interest in the real property as a tenant in common. They have to retain the real property for at least 5 years after mama dies. They could consider selling and buying it to or from each other or their grandchildren. And it was precatory language. The mom said, these are my requests and suggestions. But then she turns around and does this trust amendment where she doubles down and it's no longer precatory. And here's the gist of it, but it's just like, this house stays in the family or else you sell it on the cheap to each other. And the probate court said, that looks like an unreasonable restraint on alienation. Mama's wishes in the trust amendment were mandatory, not precatory. And there's a prohibition in California on unreasonable restraints on alienation that's applied to real property transferred through testamentary instruments. Just like I talked about the basic principles in partition actions, you can apply the same thing over here. You can't force someone to be a co-owner of real property in California. If they want out, they can get out. So the amendment unreasonably restrained alienation by precluding an open market sale of the property at its fair market value, and it was void and the original trust was operative. This is all what the trial court found. And the court didn't compel the sale or distribution of the proceeds. They left that for a future determination. And this went up on appeal. Here's my favorite slide in the whole presentation, because only I would make a slide that looks like this. So see, the unreasonable restraint is repugnant. Okay, unreasonable restraints on alienation are repugnant under common law. What does that mean? If property is conveyed in fee simple, but it's subject to a condition restraining its alienation, the conveyance is valid, but the condition is not. In the state of California, under Civil Code Section 711, conditions restraining alienation when repugnant to the interest created are void. So just walk around thinking of this slide and keep laughing to yourself. An unreasonable restraint is repugnant. You're welcome. Civil Code Section 711, conditions restraining alienation when repugnant to the interest created are void. Unreasonable restraints are prohibited. Reasonableness is they weigh the justification for the restraining condition against the quantum of restraint the condition actually imposes. And in conveyance of a fee simple interest, any restraint on alienability defeats the purpose of the interest created. Here's some case law that applies this in the probate context, and the Court of Appeal agreed with the two kids. You can get out of it. How are we on time? We're doing great. Hamlin versus Gendai, not Zendaya, Gendai. Barefoot's recipe has more ingredients. Here's the Barefoot Contessa in all of her glory. Potential intestate heirs who were disinherited by the trust had standing to contest the instrument despite not being a trustee or beneficiary under Probate Code Section 17200. Let's take a look. Facts. Professor died. Oh, this one came out of Alameda County, and it was a long and arduous trial is what the Court of Appeal decision made it sound like. So here's what happened. Professor died. Survived by two sisters and a student friend who came and helped her in the last years of the professor's life. She was called Doctor throughout the opinion. The trust named the friend as the trustee and sole beneficiary of the trust. Of course, someone who comes in at the end of someone's life, we see it all the time in probate, all of a sudden they're in all the trust and estate documents. So the sisters turn around and petition to invalidate the trust on the grounds of undue influence, lack of capacity, and forgery. Probate court had a 17-day bench trial. Ouch. They found the friend exerted undue influence over the professor to execute the trust and granted the 17200 petition invalidating the trust and transferring assets to the special administrator of the estate. The Court of Appeal affirmed the sisters as potential intestate heirs of the professor, disinherited by the trust, had standing to contest the instrument in the probate court, and their petition was not barred under Probate Code Section 17200, and substantial evidence supported the court's findings of undue influence. So remember that case that took this state and especially county by storm with Mr. Nate Pastor? It's Barefoot versus Jennings that went up to the California Supreme Court just a couple of years ago. There was a carve out in that opinion that did not discuss standing in a certain respect, and this is the blank that this court opinion fills in. So hearkening back, standing in probate proceedings is a fluid concept that depends on the nature of the proceed. A fluid concept, see, Barefoot Contessa, Barefoot. A fluid concept that depends on the nature of the proceeding before the trial court and the party's relationship to the proceeding, as well as to the trust or estate. So take a look at Probate Code Section 48. It talks about interested persons, and there is some leeway on who is interested in certain proceedings. So the probate court has flexibility to determine whether to permit a party to participate as an interested party in a probate proceeding. And here the disinherited sisters who were saying this one trust beneficiary, we're contesting her. The court said that those two sisters had standing. Anyone having an interest in a estate which may be affected by a probate proceeding. So the Supreme Court examined it in Barefoot. Standing to petition under 17200 extends not only to current trust beneficiaries, but also to individuals formerly named as beneficiaries. So if you take here's what Barefoot came from. And I saw it like a decade ago and people were like, oh, that's not how it's done. Don't worry about it, stupid young associate. But if you really read that statute, it says a trustee or beneficiary may petition concerning the internal affairs of the trust. That's what that whole case came down to. There were disinherited heirs that are no longer a trustee or beneficiary, but they would have been. And the California Supreme Court stepped in and said, they still count as interested parties. Don't read that statute so literally. That's barefoot in a nutshell. So the probate court has the inherent power to decide all incidental issues necessary to carry out its express powers to supervise the administration of the trust and wide latitude. Take a look at the magic probate code section 17206, in which the court has powers to administer trusts however they see fit. They can make orders and take any other action necessary or proper to dispose of matters presented by the petition. This code section comes up in a lot of litigation, including Breslin, so just be aware of it. The question expressly left open by Barefoot that was filled in here is whether an heir who was never a trust beneficiary has standing under the probate code to challenge that trust. And the Court of Appeal here answered that question and said, yeah, it's not so limited. All right, next, Smith versus Myers. In this instance, let's get some wind so I can look like Taylor Swift. The trust amendment was not a promise to make a will or trust subject to 1 year statute of limitations under CCP sections 366.3. So here, was this a promise to make a will or just tales from the crypt? Yuck, yuck, yuck. Facts. Decedent, wife, daughter, daughter's husband. Those are our players. Decedent made a trust, says, I'm purposefully not leaving anything in here to my daughter. I'll make a gift to her outside of the trust. It was silent on leaving anything to her husband, and it gave the settlor's ranch to the wife. Decedent then amended the trust and said daughter and her husband would receive the ranch, and wife would receive income from the ranch for her life. Decedent died, wife became trustee, off to the races. Let the litigation begin. Okay, daughter and husband filed a 17-200 petition to confirm the validity of the amendment and remove the wife as trustee, saying, hey court, can you please find this amendment valid and remove the wife? So wife demurred, husband was time barred and said husband's time barred under 366.3, the daughter's husband was time barred under CCP section 366.3 and failed to file his claim that the decedent left a testamentary gift through a trust amendment within 1 year of the death. And the trial court overruled the wife's demur in its entirety, and the wife responded to the 17-200 and said in an affirmative defense, statute of limitations 366.3. So remember, there's a contract to make a will statute in the probate code that says decedent promised to give me a portion of their estate in their will or trust. And there are specific provisions that you can meet to prove that. So that's what's going on here. So the daughter and husband filed a 17-200 petition saying, can you approve the validity of the amendment and remove the wife as the trustee? And the wife's turning around and saying, well, this is really a contract to make a will, and there's 1 year statute of limitations in the Code of Civil Procedure about that. So the wife filed a cross, but that's what's going on here. The wife filed a cross petition to invalidate the amendment, filed a motion for summary adjudication to the 17-200, and the trial court concluded that the statute of limitations did not apply because the petition was under 17-200 regarding the internal affairs of a trust, not a promise relating to a distribution. Wife filed a motion for reconsideration, which was denied. There was a trial and there was a judgment in favor of the daughter and her husband, and wife appealed. Here was what the unsuccessful argument was based on. Civil Code section 366.3 says if a person has a claim that arises from a promise or agreement with a decedent to a distribution from an estate or a trust under another instrument, whether the promise or agreement was made orally or in writing, an action to enforce the claim to distribution may be commenced within 1 year after the date of death, and the limitations period that would have been applicable does not apply. 1 year from date of death to bring a claim that decedent promised to make a will or trust. That's the statute of limitations. That's what the spouse tried to argue here. And as courts do, they look to the plain language of in order to interpret the statute. And they said it only applies if a claim is based on a decedent's declaration that they would do something or refrain from doing something specified in arrangement, where they promised to make a will or a distribution from the will or not. And that plain language interpretation, as the Court of Appeal always looks at, was supported by legislative history. So Civil Code Section 366.3 does not apply in this case. Thanks for trying to be creative. Didn't work here. It doesn't apply to the daughter and husband 17200 petition to validate the trust, because they're not alleging that there was an agreement or promise to make the will, and decedent made a binding promise that they would get the ranch when he died. They're not alleging those two things. Instead, what they're alleging is the amendment. The trust amendment itself requires the distribution. The amendment is valid, and they're entitled to receive the distribution under the amendment. The 17200 petition was all about the trust amendment. It was not hearkening to any other outside agreement or contract or promise to leave them something. They're just saying, hey, look at the trust amendment. So Court of Appeals nugget here said the wife makes various efforts to strain the plain language of the statute to make it fit the 17200 petition, none of which are persuasive. Plain language, the statute of limitations of 366.3 applies to claims based on promises or agreements to create an instrument that will effectuate a distribution from the property of a decedent, rather than to claims based solely on the instrument effectuating the distribution. So there's the plain language of the statute. The claim at issue would be to enforce a promise or agreement. That wasn't what was happening here. Wife's arguments were unpersuasive because the trust itself is not a promise or agreement. Like, you're straining, dude. You're saying that a trust amendment is a promise or agreement to make a will. No, it is the will. Person. Okay, so in making the amendment, the decedent did not legally bind himself or otherwise irrevocably commit to ensure the ranch was distributed to daughter and husband upon the decedent's death. Decedent could have amended the trust also during his lifetime without breaching a promise or an agreement made. So they looked at the legislative history, and in the end, the Court of Appeal affirmed the judgment, ruling on the motion for summary adjudication and on the ruling on the motion for reconsideration. Daughter and husband recover their costs on appeal. Remember, that's where you really get hit with the fees and costs. So think about these appeals. So they recovered their costs, and there's the daughter walking away with the ranch. Next, Newman versus Casey. I can be your hero, baby. P.S. Where's Enrique's mole? But you can't take the deed away. So the court properly granted elder abuse restraining orders in this instance for financial elder abuse, but it exceeded its statutory authority in declaring a deed void as a part of that TRO, temporary restraining order. This one's pretty interesting. Facts. Daughter told mom, here, sign all these things to protect your house from taxes. And of course, mom didn't really read it or understand it and said, sure, and signs. Documents were actually transfer deeds of the house to daughter. Evil, evil, welcome to probate court. Mom files an elder abuse restraining order, and the daughter's attorney says, well, this was all a part of the estate plan, and it really is to save taxes and Prop 19 and da-da-da. And the mom goes, oh, nay. My daughter threatened to put me in an old folks home, you know, Shady Pines, ma. And I've been getting calls from realtors to sell my home. This daughter, she's making this case out to you like this was all part of our divine plan, and she is not nice. So she tricked me. And the trial court issued an elder abuse restraining order. I think this was Judge Juhas in LA. The elder abuse restraining, or maybe, I might be wrong. The elder abuse restraining order added into the language a prohibition in the additional orders section that the daughter take no action whatsoever to encumber the property. She have no communication with any realtors, mortgage broker, etc. to sell or as it relates to this property. And at the end, it said the court would consider adding an order that the daughter sign a rescission deed after briefing and argument by counsel. So, hey, attorneys on both sides, go out and brief for me whether or not the daughter should sign a rescission deed, giving the real property back to mom that daughter had her sign over. So daughter files a request for reconsideration, an objection to the elder abuse restraining orders, and briefing on the authority of the court to order rescission. the mother abandoned her request for rescission, and the attorney walks into the court and says, Judge, the simplest way to go about this is just void the transfer deed, ab initio, make it like it never happened. But remember, what is pending are elder abuse restraining orders. So he's going, hey, rather than briefing and rescission deeds, how about you just void it, Judge? You're all powerful. No, you're all powerful within the confines of the law. So the trial court denied the, so let's see what happened. So here, first, the trial court denied the request for consideration and ordered the daughter to return the property to mom within 30 days and said, yeah, the deed's void ab initio. And this matter was appealed, and the trial court said, oop, you did that wrong. Court of Appeal affirmed in part and reversed in part. There was sufficient evidence to support the restraining orders, and the Court of Appeal discusses the 4 factors that support the undue influence finding, and they found that the witnesses were credible to support the trial court's decision. However, where the trial court made its misstep was that it issued the subsequent order declaring the deed void. That's not part of an elder abuse restraining order. Also, an elder abuse restraining order, the effect of a temporary restraining order can't last more than 3 to 5 years. And if you're voiding a deed, that's more than 3 to 5 years. That's for the foreseeable future until something else comes along. So you can't void a deed as a tack-on order, additional order in an elder abuse restraining order. The Court of Appeal then goes through and talks about Elder Abuse Dependent Adult Civil Protection Act, EDICAPA, and that's at Welfare Institutions Code 15657.03. And it talks about the type of restraining orders a court may issue when it deals with an elder or a dependent adult, and the summary and initially provisional remedy to secure the immediate protection of elders for further abuse. That's what's going on. To protect the elder, the temporary restraining order may provide a sufficient remedy, or if not, you may need a separate civil or probate action for elder abuse. So in this instance, they filed the temporary restraining orders to get the house, maintain the status quo of the house so that it wasn't sold yet, even though the transfer documents were signed. And instead, the petitioner should have gone on and filed an additional petition in probate court to void the deed ab initio instead of doing it as a tack-on order. No shortcuts allowed. Next, Key versus Tyler. If you fight my trust, you will lose it all. So if you fight me, you will lose. So the amendment contest was a direct contest of the original trust here. So someone was contesting an amendment of a trust, and that was a contest of the whole trust because of the language in the no contest clause of the original trust. So the share of residue pursuant to the amendment was not exempt from forfeiture under no contest clause law, and the law does not limit the scope of no contest clause to that settlers may impose. So you can say whatever you want in your no contest clause. So here's what happened in this case. Key appealed from an order denying a petition to disinherit her sister, Tyler. Sister. The petition sought to enforce a no contest clause in their parents' trust. There have been 3 prior appeals of orders concerning the same trust. This case is a saga with several appeals that have gone up and come down, some of which are published, some of which are not. Here's the latest. The new issue. The trust amendment changed the residue, and that amendment did not include a no contest clause. Does that mean that Tyler's share distributed under the amendment are exempt from forfeiture? Trial court Judge Juarez said yes. Court of Appeal said no. The holding rests upon, as usual, the plain language of the statute, or in this instance, of the original trust's no contest clause. So look at the original trust, and the no contest clause in that original trust says, if a beneficiary contests the trust, the settlor shall disinherit them, and that all interests given to that person under this trust are to be forfeited. The plain language requires that if Tyler lacked probable cause to contest the trust, she must be disinherited, and her share of the residue is not exempt from forfeiture simply because her specific share was specified by an amendment that does not contain a no contest clause. What does that mean? Okay, so here's what happened. Let's make sure. Okay, trust contained a no contest clause. Trust amendment did not. Tyler moved to bifurcate the trial on Key's no contest petition, arguing the dispositive issue arising from the absence of a no contest clause in the amendment. They argued if it's not a protected instrument, it's not subject to forfeiture. Probate court agreed and dismissed with prejudice Key's no contest petition. This was reversed and remanded to determine whether there was a lack of probable cause for direct contest. In the prior appeal, one of them, the court decided that Key had provided sufficient evidence of a probability of success on her no contest clause petition to defeat Tyler's anti-SLAPP motion. Yay, anti-SLAPPs, my favorite. It established the existence of a direct contest, but did not decide its consequence and didn't decide whether the amendment was a protected instrument. So there is no statute that exists that limits the scope of forfeiture that a no contest clause may impose. Interesting. I wonder if there will be in the future. Who knows? This is how laws eventually get made. Ideas pop up where there's no law on it. Okay, so here, in this case, the no contest clause states that a direct contest without probable cause requires forfeiture. This trust no contest clause says this trust or any other trust created by a trustor, basically, the no contest clause says if anyone ever comes forward and contests this trust or any other trust created by the settlor, the no contest clause applies. So it applied to a future amendment that could be made. Tyler argued the forfeiture language doesn't specifically refer to an amendment contest. The Court of Appeals said no, that equals an amendment. So there was no dispute that Tyler also directly contested the original trust. The question was whether trustors intended to limit the forfeiture that would result from such a contest only to those assets in the original trust, and the answer was no, the no contest clause language in this trust does not support this conclusion. The scope of the forfeiture of the trustors intended is not limited by law, and no contest clause statutes don't limit the scope of a forfeiture that may result permissible scope of forfeiture from an actual direct contest of the protected instrument. In the last few pages of this opinion, it discusses relevant case law, which are shameless cross-reference, shameless plug, also referred to in this article that I wrote a few years ago for the Trust and Estates Quarterly. But ten cuidado, have caution is what that means. This article was not well edited. You'll see that in a couple of glaring ways, but the case law that was referred to in the Court of Appeal decision is in there from a couple of years ago. Next case, 5 lessons in elder abuse and trust litigation. This is Asaro versus Maniscalco. So here's what happened. A son could sue a trustee for elder abuse of the mother after the parents died, did so properly, and the court awarded damages plus double damages under Probate Code Section 859. So what is this case? This is a how-to guide on elder abuse and trust litigation, and by the way, putting to bed what 859 damages means, double damages, as we refer to it. So here are the facts. There was a family trust of deceased settlors, Nicola and Antoinette. Anthony Asaro is a trust beneficiary, and John is former trustee and beneficiary. So John is former trustee, Anthony is a beneficiary. Deceased settlors are Nicola and Antoinette. Got it. Okay. Got your chart? Anthony brought claims against John for breach of fiduciary duties owed to the trust and financial elder abuse of Antoinette. And John argues these 5 points. Anthony lacked standing, claims were time barred, they were released pursuant to a settlement agreement, elder abuse claims were not supported by substantial evidence, and the court improperly calculated 859 damages. Let's put each of these 5 points on one slide apiece. Standing. The court held Anthony had standing to assert elder abuse claims on behalf of Antoinette. John's argument that Anthony needed to be successor in interest was unreasonable. Elder abuse claims on behalf of a decedent. Who has standing to bring those? After the elder or dependent adult dies. So the right to commence or maintain an action belongs to the personal representative, unless there's no personal representative. The personal representative refuses to maintain an action, either because they're the one accused, more often than not, or they think it's a bogus claim to go after, or the personal representative's family or affiliate allegedly committed the abuse, then someone else can bring it. So if there's no personal representative, the standing passes to any of the following persons: an intestate heir who has an interest that's affected by the action, the decedent's successor in interest, or an interested person, not including a creditor or a person who has a claim against the estate that's not an heir or beneficiary. There's your lesson on standing. Ladies and gentlemen, there's your lesson on standing for elder abuse claims on behalf of a decedent who has passed away. Next, statute of limitations. Part A, breach of fiduciary duty claims. The court here held that Anthony's claims were not time barred. He had no reason to know of his claims more than 3 years filing his suit. These cases often come to us where we're going, gosh, they're alleging things from like a decade ago. What took them so long to find out what happened in this trust and estate case? And these are your guidelines to look at whether or not that's something that affects the statute of limitations. Because people always say, oh, they had no reason to know or should have known that these breaches of trust were occurring. Well, that's where you look. Should they have known? So here are the standards. Beneficiaries of an irrevocable trust, typo, have their own causes of action against trustees. They're not derivative of the settlor's rights. Remember Geraldine, that big case that came out like a decade ago? So once a settlor dies and a trust becomes irrevocable, beneficiaries have standing to sue a trustee for breaches of fiduciary duty committed during the period of irrevocability. Here, Anthony's claims for breach of a trustee's fiduciary duties to the trust had to be brought no more than 3 years after the beneficiary discovered or reasonably should have discovered the subject of the claim, and the statute of limitations is expressly measured from beneficiaries' discovery of the subject of the claim. Next part of statute of limitations in this case, elder abuse claims. Anthony's claims for financial elder abuse of Antoinette were timely because of delayed discovery rule. What does that mean? The delayed discovery rule postpones the accrual of a cause of action until a plaintiff discovers or has reason to discover the cause of action. So claims for elder abuse have to be brought within 4 years according to 15657.7 under the Welfare and Institutions Code. 4 years can be extended or tolled because of the delayed discovery rule. If a person at the time a cause of action accrued is either a minor or lacks legal capacity to make decisions, the time of that disability is not part of the time limited for the commencement of the action. And then after that person dies, their successors have at least 4 years after that to file a claim. Third, settlement agreement did not release claims. Anthony was not bound by the settlement between John and Nicola. So the surviving settlor, Nicola, alleged that John misappropriated assets and removed him as trustee, and John sought to remove the new co-trustees that were appointed instead of him after he was removed, and sought to appoint a conservator for Nicola. He said, you're going to remove me as trustee? I'm going to conserve you. You're out of your mind. There was a mediation and a settlement, and the trial court found that Nicola did lack capacity and there was no notice to Anthony by John. So the settlement agreement was fundamentally flawed. Here are some good principles to move forward with in your practices. Trustees generally cannot escape liability if a beneficiary did not know of his rights or material facts, or if the releases are not fair and reasonable. When there's a trustee of an irrevocable trust, they can't release beneficiaries' claims for breach of fiduciary duty against a prior trustee without notice or consent of those beneficiaries. It's their rights that are affected. The trustee is the office of trustee, but at the end of the day, the ball goes to the beneficiaries. So they need to have notice or consent. The beneficiaries of an irrevocable trust have their own direct claims for a breach of fiduciary duty. The right to release a claim belonging to the trust does not empower a trustee to release claims belonging to beneficiaries. And as an aside, this is an interesting footnote. A confidential settlement of elder abuse claims is disfavored as a matter of public policy because such terms are presumptively unenforceable. Confidential settlement of elder abuse claims is disfavored. You can use that moving forward. The fourth claim was not certified for publication, so we're going to skip it. That's me presenting. Me skipping this point, and those of you still listening. All right, fifth and final point of this case. Probate Code Section 859 damages. You'll want to perk up your ears for this one. The trial court did properly calculate the penalty and assessed it against John personally. So there was some dispute a few years ago over what 859 double damages actually meant. And here's what happened in this case. So people have argued, I will not name them, but people have argued it's essentially treble damages. And it is, but don't call it that. So what happens under Probate Code Section 850 cases where there are 859 damages is the claim that you can recover on is you can get compensatory damages for the amount of money that's been taken, plus you can get the 859 double damages for the amount of those compensatory damages times 2. So this one plus up to 2 times that amount equals 3 times the harm that was initially incurred. But don't call it treble damages. It's something different. It's the compensatory damages under 856 plus 2 times those damages under 850 is 3 times the harm. Read the language of the statute in 859. People don't read statutes anymore. Like, look to the language of the statutes. So this is compensatory damages plus those double damages, and return of the property is remedial plus damages that are punitive in nature. Pet peeve, people go, oh, 859 damages are punitive. No, they're punitive in nature. They are not in and of themselves punitive damages. Punitive damages in probate matters can be sticky. Do your research if you're asking for them. So here they found the trial court could award the 859 penalty directly to Anthony. So not only did the trial court award the penalties, but they did so directly to Anthony. And what John was trying to argue was you have to put it back in the trust and then award it. And the court was like, no, we can award it directly to this beneficiary. And that was a reasonable exercise of the court's discretion. Court of Appeal said, you're kosher. So the statute discusses liability, not the party to recover it. Interesting case. Phew, that was a long one. We're still good on time. Haggerty versus Thornton. So it is written, so it shall be done. This is a California Supreme Court case that came out last year that finally put to bed the interpretation of Probate Code Section 15402, something that I filed my very first appeal on as a baby attorney over a decade ago, that after I left that firm, they dismissed. Ain't you sorry now? Okay, so under Probate Code Section 15402, a trust may be modified via Probate Code Section 15401, procedures for revocation, unless the trust instrument provides for an explicitly exclusive modification or otherwise expressly precludes the use of revocation procedures for modification. So if you look at Probate Code Sections 15401 et sec, it says that a trust can be revoked or modified in specific ways, and you really got to closely read those statutes. And the courts of appeal had a split of authority in reading those statutes, so this went up to the California Supreme Court. And one of the cases mentioned in the briefing from the parties and the amicus parties was one that came out of our very own Judge Sugiyama. So bravo to that. Okay, so methods for modifying a revocable trust. Unless the trust instrument provides otherwise, the settlor may modify the trust by the procedure for revocation. So unless the trust says otherwise, like explicitly says it, you can modify a trust, the settlor can, by the same procedure in which they would revoke it. So how can you revoke it under the statutory method? Trust may be revoked by any method stated in the trust instrument. And if the trust says this is the only way you can revoke it, then that's the only way you can revoke it. But if the trust states a method but doesn't say it's the only way that you can revoke it, then it can be revoked by the statutory method as well as the method stated in the trust. So it has to say this is the only way. So there's the statutory language. We've talked about this the last few years of these presentations. If a trust is silent on modification, you can modify it in the same manner as you can revoke it via the statutory method or any method provided in the trust. This is my face after toiling away at this case since I was a baby attorney. This authority. Like, finally, put it to bed. I'm so sad. I wanted to discuss this years and years ago. Okay, so the issue, I've been watching it as the years have ticked by, going, it's right there. So consider the circumstances under which the statutory method is available for modification if the trust instrument specifies a method for modification. And the California Supreme Court finally came forward and held under 15402, you can modify a trust via 15401 procedures for revocation, including the methods in the statutes, unless the trust instrument provides a method of modification and explicitly makes it exclusive. or otherwise expressly precludes the use of revocation procedures for modification. I boiled this down really simply. The trust says shall, not only shall. That's it. That's what it came down to in my case. All right, here are the facts. Aunt create a trust, include a provision reserving the right to revoke or amend it. The aunt amended the trust, providing for distribution to the niece. The aunt signed and notarized it, amended the trust, providing for distribution to others, not the niece. She signed that and did not notarize it. The amendment was compliant with the statutory method, but not with the method of modification specified in the trust instrument. The niece filed a petition to determine validity of the last amendment. The probate court found the trust agreement was validly amendment and excluded the niece from distribution. Court of Appeal affirmed, holding the amendment was a valid modification pursuant to the statutory method, which was available because the trust didn't distinguish between revocation and modification, and the methods of such are not explicitly exclusive in the trust. Here, the California Supreme Court granted review because of the split in authority regarding circumstances under which the statutory method is available for modification when a method is specified in the trust instrument. And the conclusion was the statutory method is available unless the trust instrument, quote, quote, provides otherwise. That's the language of the statute, by expressly making a different procedure exclusive. Affirmed and remanded for further proceedings consistent with the opinion. So I see at this point in our game that we have about 5 minutes left. So I'm going to do a speed through to just introduce you to the rest of the slides that you have in your materials so that you can look up things on your own. So Herod versus Country Oaks Partners. This is an ode to Advanced Healthcare Directive Law. This is the book on Advanced Healthcare Directive Law that you want to read to understand what healthcare decisions can encompass. Spoiler alert, they can't encompass arbitration agreements with facilities. So that's Herod versus Country Oaks Partners. Next, Grossman versus Wakeman, not the client. Wake up all you estate planning attorneys, take a look at this case this year. It talks about a civil legal malpractice case that a beneficiary or an heir brought against the estate planning attorney, and the attorney owed a duty to his client and not that kid, not the client's child or grandchildren, because the client left everything to his wife, and it was not the duty of the attorney to second guess what the client wanted to do for the child. Next, Prang versus Los Angeles County Assessment Appeals Board. So this is tax stuff. This talks about change in ownerships. So take a look at that when it involves corporate real property by shareholders, whether or not they're voting shareholders. Next is Marriage versus Diamond. This was an interesting case. It's not probate. It's a family law case, but it's really important because it kind of blows the lid off of things, because it's a family court case that says there are no definitions of, I think it was incapacity or undue. It was incapacity and incompetence. So they looked at civil statutes, they looked at probate code statutes, and they applied those by analogy to a family court proceeding. So I can smell statutes coming in the family code in the future about having what mental incapacity means, or just the general application of the probate principles to it. Conservatorship of KY, don't do the moot boot. So what this is when it's kind of a warning from the Court of Appeals to lower courts, like, look, when you've got an LPS conservatorship or other types of proceedings that are time sensitive, that need to be decided, just because you keep continuing it out for further briefing or whatever, and in the future, like, you think the appeal doesn't need to go up because it's moot, we can still look at it, and you should be aware of these time constraints, and you should be moving this thing along, and attorneys also have a duty to be aware of that and inform the court of those things. So here are the details on good cause intended to balance competing policies about time limits, expeditious matters, etc. My internal voice, George Costanza. Here's guidance from the court on whether or not you should moot something, or wait it out until it's moot, I should say. Next is conservatorship of TB, and that's that a statute's time limit was directory, not mandatory. That's kind of weird. You would think that something written into a statute as a statute of limitations would be what you follow, but here it wasn't mandatory, it was directory. So that's an interesting matter, and that's all we've got. With that, I will take any questions. Y'all still with me? Did I cause any strokes? Okay, let's see what's in the chat. Is this slide deck available to download? I provided the PDF materials of this. I also provided, in line with what I used to do for the probate breakfast and the probate lunch to the bar when I worked for this court, I provided a list of cases. It's a hobby of mine to follow all the appellate decisions throughout the year and just jot down which ones I think could be relevant to our areas of the law. They not necessarily are, but they could be. And so I provided that comprehensive list to you. Note that those summaries come from the Daily Journal. I don't take credit for the summaries, but I do take credit for following the appellate cases all year and compiling them into that list. So go forth and do good work, and I hope that these things help you. And remember to always shepherdize those as well. Thank you very much. You're welcome. Great. That's it. Any other questions? Compliments? Hold your complaints, please. Lovely to see you all. Thank you for having me. I'm here. I'm in Contra, Costa County, Bay Area born and raised, so I'm not going anywhere. Hope to see you all soon. I am in LA quite frequently, but I hope to see you between that. Yay for LA also.
Thank you, Julie, so much. We really appreciate your comprehensive updates. Your hobbies are a little different than mine, but I'm glad your hobbies are what they are so that you can provide your knowledge to the rest of us. So thank you again. We really appreciate you taking the time today.
Sure. Thanks for having me. Good to see you.
Yes. Thank you, Julie. Thank you, Tracy. Thank you, everyone, for attending. I hope you have a great rest of your week and a great weekend.
Thank you.